basically, that's a little map of what it is that we're going to be doing in this subject. So we really are confining everything to matters that relate to how contracts are made, and then a little bit of, if they're written down, how do we read them? If they're not written down, how do we work out what the terms of the contract are? The rest is basically the stuff that you will do in advance. So this little map here literally comes from what used to be called the Butterworth tutorial service. I wanted to mention that there are a whole lot of these resources online, and the encyclopedias can be really helpful, particularly to just get the high level of what is this topic about, why are we looking at these cases. So actually thinking about how they set in, they're quite easy to read, and so both the Laws of Australia and Halsbury's Laws of Australia are available through the library, and you can get access to them quite easily. We've done that already. We did that activity already. I'm going to shoot through some of these because I've spoken about these things. I hope that from that little exercise that we did, you've got a sense that contracts are an integral part of doing business. It is worth thinking, though, that most of the time in this subject we're going to be thinking about the common law. Yet there have been legislative interventions that sit over the top of that. And as we go through the next series, I want you to think about the reasons why that might have happened and whether or not it's a good or a bad thing. Why is contract law so ancient? Why? I mean, at the moment you're just believing me, I hope, that it doesn't change all that often. But if you take that at face value, start to think about, well, why doesn't it change all that often? We do that next activity as well, and I'm going to skip that one for a moment, and we'll get back. So we've defined what a contract is already. I want to talk to you about a circumstance where I had to define a contract many, many years ago. My kids, one of them at least is older than some of you, I'm quite sure of that. But when she was in grade 3 at the Catholic school in Williamstown, we had a careers day, and she was very excited that I was going to come to school and talk about my career and what I did as a job. And I got the slot that everybody dreads. The dad who was before me was a fireman, right? Like, you just cannot win in that slot. And it really, and my kids have always really kind of distanced themselves from being a lawyer, having anything to do with the law. They're, in their heads, what I do is the most boring thing that they can imagine. My son actually at one stage told his friend who was over for a play date, please be quiet, because if you aren't careful, she will tell us what she does at work, and it's so boring we will die. He was, again, about 7 or 8 at the time. So I really wanted to spend some time thinking about how do I explain what a contract is to a group of 7-year-olds. And I think as a general learning thing, being able to explain something so a 7-year-old understands it actually demonstrates that you understand it really well. And it's a really good study tip. If you think, how do I, is this making sense? Do I really understand it? Try and explain it to a 7-year-old, because they will ask sideways questions, but they need it spelt out in a way that makes sense, and you need to understand it to do that. So I talked to them about playing cricket on the street. Again, that's how old my kids are, is that they still used to play cricket on the street in summer. And so you think about it, it's summertime. For those of you who weren't brought up here or brought up in the suburbs of a major city, this might not make as much sense. But basically, particularly in, from time immemorial through till probably the mid-2000s, as far as I see it, kids would play cricket on the street, on suburban streets, on summer weeknights. And, when it's hot, and, you might have some mums or dads sitting on the gutter with a drink or a chat. And basically, a game of cricket like that always starts off with the rules. And you work out what the rules are. And the rules usually include things like over the fence is 6 and out. Anybody recognise a rule like that? Somebody hits the ball so far, goes over the fence. Well, you get points for it because it's a good hit, but you've slowed down our game, so you're out. Or if, usually you've got rubbish bin for wickets or whatever. When I was a kid, they were metal, so they made a great noise. But if a rubbish bin didn't, if the lid came off, that was an extra score of some sort, get some extra points. If your ball went into the garden of the crabby lady on the corner, then the person who hit it had to go and get it, because nobody wanted to do that. But at the same time, when everybody's out having a good time and it's somebody's little brother's first time ever at bat and they go out for a duck, usually you just let them have another go, right? So basically, that's my job as a lawyer, as a contract writer, is to write down those rules. But at the same time, the expectation as a lawyer is that when somebody's little brother is batting for the first time and everybody's happy for him to have another go, then your rules are going to be completely ignored. But if it's 9:15 at night and somebody's mum has called from the front door 4 or 5 times and has that tone in their voice, then over the fence is definitely 6 and out. The rules apply when the stakes are high. And that's ultimately what we do as lawyers. We write down the rules of the game. Historically, that has been a game that's been invented usually by white men in suits, a large part of what we do, but not so much anymore. What we are trying to do is understand what it is that the parties are really agreeing to create the noun, to create the contract document. And to do that in a way that is sufficiently certain and complete that if something goes wrong, that we've already identified what the consequences of that are going to be. So that's a very long-winded definition of the contract, but that's kind of what we do. So I've used this phrase a number of times, I'll probably use it again, that contracts, here we're interested in the verb. So when I went through that list of elements for contract, can you remember them? Agreement, made up of offer that's matched by acceptance that has been communicated. Consideration, we'll call that price for the moment. Intention, to create a legal agreement, and certainty. Once we have all of those elements, there's something that often we think about but just is missing. We do not need to have anything in writing in order to have an agreement, in order to have a contract at Australian common law. So something in writing is not a necessary element. Now, there will be circumstances where a contract will not be enforced unless it's in writing, and we'll get to that when we talk about formalities. But ultimately, writing something down is not making a contract. A contract is made and it is recorded. It might in fact be made by signing a document that might be the moment of acceptance, but writing and contracts are separate concepts. Why do we have a contract law at all? So one of the questions that legal philosophers, jurisprudential scholars have asked themselves, oh sorry, I've already forgotten to keep up on the recording here, just give me a second, come on. Oh, I will catch up. I might just give you this video, we'll work it out, okay? What are the reasons? Going right back, some of it is just moral reason. And you will find as we go through particularly some of these older cases that they carry with them the social morality of the times in which they were decided. And sometimes that creates issues for us later on. But there is a moral explanation, this idea that ethical people keep their promises and that it is good for business if people are ethical. There's also this idea that parties to a contract have consented to being bound. So this brings us into this idea of contract being a private law, an idea that I'm going to come back to over and over again as we examine these separate jigsaw pieces. So how many of you are doing torts at the moment or have done it in the past? So quick show of hands, around half, possibly slightly less than half. Torts is about public laws. So rules that apply regardless of your relationship with someone else. So obligations to keep something that you have control over safe so that other people aren't inadvertently harmed by it. Criminal law is a public law. It applies to everyone. But contracts are a beast that create a separate little law just between the parties who have agreed to enter into that agreement. So a contract basically creates an obligation, a legal obligation for someone to do something in exchange for something else. Usually to deliver a product or a service in exchange for payment. That's probably the most simplest form of contract. So somebody had put in that one of the most recent contracts they had entered into was buying a cup of coffee. So the terms of that contract require the delivery of a cup of coffee as specified in exchange for cash. Contract's been and gone once all of that is done, but basically there is a private set of rules. Whether or not somebody's going to sue if you don't actually hand over the cash or sue in contract, it's probably more likely to be in theft these days, but and that's just cost of enforcement. But it is simply an exchange. Also, this idea, this moral idea that if you are a party to a contract, you do something for or with the other person in reliance on the promises that they've made to you in exchange. So this idea that if you say you're a whiz at maths, there'll be somebody in this room who is, and that person no doubt has spent time tutoring other people. They might spend some time helping another family member or a friend with calculus. They do that out of love and affection, and to keep their mother from nagging them. However, if they go out and do tutoring for a living, they spend their time giving maths advice to somebody in reliance on receiving payment for doing that. So there is this moral idea that sits behind it. But I think the practical perspectives in this day and age are really worth thinking about as well. Because almost every country, even though every country's or every legal system's contract rules are slightly different from each other, it is quite usual for contract systems to run for a long time, to not change a great deal, and to have very similar concepts sitting behind them. And that's because the nature of contract is entirely commercial. It is a commercial relationship. And it is good economically, in an economic sense, for commercial people to do things consistently. And it is good for governments and for economies for people who are investing to know what the consequences are if contracts are broken. So there's some stuff in the textbook, Michael Trebillick as well. It's quite interesting there. I don't need you to do much more than just be aware of these concepts at this stage. There is a very small chance, I haven't written it yet, that an exam will ask you, well, there's a very large chance that there'll be an exam, say 100 to 1. There is a very, very large chance that that exam will include a critical analysis question, a question where you need to tell me what you think about something. And so all the time, I don't really spend separate time thinking about critical analysis. We will just keep raising issues like that. So it's not a stupid question to see on exam, it's never been there, but something like, why do we have contract laws in the first place? What is the benefit? Do we need them? What do you think about it? What would you change? So they're the kinds of things that you need to be thinking about all the time. is impossible to read on the screen. It's probably not much more help to you in the notes that I've put together, but I think it is kind of useful to see that there have been, oh, it's not going to be clever, shame. There haven't been massive changes in the way that contract law has evolved in a common law system. So this is Australian common law that we are talking about, but up until really until the 1980s, that was in a common law sense directed by the ultimate decision makers were the Privy Council. And so we're heavily influenced by the English decisions. We do have a number of pieces of legislation that directly impact the way contracts are understood, with the exception probably of the Electronic Transactions Acts, which we'll talk about very early on. I don't want you to worry too much about other legislation at this stage, because what's important here is we're amassing these jigsaw pieces, puzzle pieces. We're going to understand the fundamentals before we see how the legislation changes them. Because if you think about it as a kind of, card game, legislation trumps common law. But the only reason we get the legislation, at risk of vastly oversimplifying, is because the common law isn't doing the job that those responsible for the legislation think it needs to do, right? And the separation of powers means that the government can't say, actually, we'd like you to decide these cases this way. Instead, they basically will provide legislation to change the rules in that sense. So legislation is a response to the fundamentals, and in theory, the legislation can change, right? So it is actually worth thinking about, well, why does the legislation fit in? Another way of thinking about this is, if we're relying on the common law to govern us, we get the law that comes out of the cases we get. Because again, like only speaking to divorced people in order to work out what a good marriage is, we only get principles of law based on the facts or the disputes that judges get exposed to. So that means we can't create laws before the circumstances have hit. So particularly in a rapidly changing world with a lot more technology, a lot more, in reality, much closer borders than we've ever had, huge transfers of information, intellectual property playing a role that it's never really played before, as so much value is transferred over the internet as opposed to in traditional ways. The law can only respond to those things as disputes come before it, where the legislation, in theory at least, can address policy issues in a different way. So it's worth just seeing. I think we're going to see more change up at this end. We're going to see more growth in legislation. And again, not a stupid question for an exam either, is if you were able to direct policy, I like this question. Hopefully I'll listen to the recording and I'll remember it. If you were able to determine an area of reform and direct policy, what would it be and why? Think about those things as you listen and engage through the rest of the semester. I think I've just explained what a private law is. Let's see if there's anything there. One thing I would like to just mention is this idea of legal personality. One of the things that can trip us up very early on, particularly because you are all new to this, is it's very easy to think about contracts in terms of human people, but then forget about companies. So a party to a contract needs to have capacity in order to be sued. So contracts can be made regardless of whether somebody has a capacity or not, but whether or not a party can be sued on that contract depends on whether they have capacity or not. We'll talk about capacity as, it's like a kind of subtopic in a week that we have two topics. I think we're going to talk about capacity and certainty all in one go from memory. legal capacity in some senses is about a human's ability to make decisions and intend to be bound. So we will concentrate most of that time on talking about children and whether they can enter into contracts, or people who are suffering from mental impairment, whether drugs, alcohol, some sort of mental unwellness, whether they have capacity or what it means when they enter into contracts. But it is worth noting that it's not just humans who have mental... actually, I suspect it is just humans who have mental capacity, but it's not just humans who have legal capacity. So a company has legal capacity. A company can sue and be sued in its own name. Unlike a human, a company does not need to be 18 years old before it can do that. In fact, under circumstances we won't talk about here, but in corporations law or company law, whatever it's called, you will, some companies can enter into contracts and be held to them even before they exist. Human beings become the eyes, ears, mouth, nose of a company. And often one of the things you have to be thinking about is, who is the real party to this contract? Is it the person who has undertaken the negotiations, who has signed the document, who has said, yes, let's go, who's handed over the money, whatever it is? Or is it a company or other organisation that they work for or that they are a director of? So the other issue that comes up often is theoretically. I'm saying theoretically because you're about to read the cases, and as you read them you will wonder whether I am telling you the truth. But theoretically, governments have legal capacity. A government can sue and be sued in its own name. A government can enter into a contract. Now, most of the cases we read, you'll see that the governments are not held to those contracts very often, unless there are particular things that happen. You will learn more about those things in constitutional law. But again, from a theoretical jurisprudential basis, it's worth remembering that it's not just humans who have legal capacity or legal personality. So, some other types of private law that might be relevant. I'm going to fly through here. We spoke about tort just a little while ago before I got to the slides. Unless anybody has any questions, you don't need to know anything more than, let's think about them. One is a public law, one is a private law. I want you to understand this idea of private law. Tina can help you with what a public law is. This is a concept that will come up a lot, equity. One of the questions that I get most often from students who are battling through these cases is, I don't understand estoppel. What is this estoppel you speak of? Many of the cases you will be asked to read will refer to this concept of estoppel, or will talk about other equitable remedies. Now again, I don't know whether you cover this much in intro or not, but it is worth remembering that historically in the UK there were two kinds of courts. There were the common law courts and the equity courts. So common law tended to be black letter law. Let's work out what the rule is. I'm vastly oversimplifying. Let's work out the rule and apply it, and that's what the answer is. It's very much more formulaic. Equity came in response to this, saying, well, when we do that, we often end up with an unfair result. So equity, as its name implies, at least in theory, was about looking at the question of fairness. And often, in a common law sense, the kind of remedies that you can get were quite limited. So let me give you an example that I think will make sense to you. Say I am a tech entrepreneur and I have this brilliant idea, this algorithm that is going to change the world as we know it. I don't know what my algorithm might do. It's some sort of artificial intelligence that allows people to interact and share any information that they want and remain entirely private all the time, but somehow weeds out the nasty bits. Like this is a beautiful thing. And you're excited by this. You've decided to work with me. And so I enter into what's called a non-disclosure agreement with you, a confidentiality agreement, right? Sorry, what's your name? You told me already. Yes. Gabby. So Gabby, I've recruited her. She's working for me. She's signed this NDA. And turns out I am a complete cow to work for. Who could have told, right? Yep, the rumours are true. She really doesn't like working with me. In fact, she's got to the point where she'd just do anything that she could to hurt me. So she's got a copy of my algorithm and she's going to give a copy to all of you. Now, I've got an NDA. Under the common law, that means I can sue her, right? But what I need to do is I need to wait till she breaches the contract before I can sue her. And so then all of you have got a copy of my beautiful algorithm. Is that what I want, to get money from Gabby? Gabby looks lovely, and I'm quite sure that she's independently wealthy, but not as much money as I was going to make out of that algorithm. No. My guess is that what I really want to do is be able to stop her from breaching the contract in the first place. Okay. When you think about that, I don't know how many of you are as pop culture mad as I am. Anybody seen the Minority Report? Tom Cruise runs around basically killing people before they commit a murder because this AI is telling him these are the people who are going to die, and then it turns on him. Like, moral conundrum. Anyway, but it's a bit Minority Report. I can't sue her before she's breached the contract. And that's where equity steps in. Equity says, well, we know that damages, money, is not going to be an appropriate remedy. You need a remedy that is fair. So I need a remedy that can stop her from distributing the information in the first place. So there tend to be two. One's called mandamus. So it's like child rearing, really. There are only two tricks to child rearing. One is make them stop things when you want them to stop, and the other is make them do things when you want them to do things, right? Mandamus, you got to stop doing something. Specific performance, you have to do something. So they're equitable remedies. So hopefully that is some sort of explanation of why it matters. Have a look at the textbook for what it means. Statute. We've spoken about statute already. I hate slides, can you tell? Especially once I've started without them, I get everything out of order. I mentioned the Electronic Communications Act, probably not written on the slide. That's one we will deal with early, which talks about circumstances in which a communication can happen via a machine, what that means, when it happens, what it means. The other piece of legislation that we'll spend quite a bit of time with in the last 4 weeks of this course is what is called the Australian Consumer Law. The Australian Consumer Law is a schedule now, Schedule 2, to what is called the Australian Competition and Consumer Act. And so the Competition and Consumer Act deals with the protection of competition, but also the protection of consumers. And so the Australian Consumer Law deals with the consumer parts of that, and it provides particular overlays that impact certain kinds of contracts, particularly consumer contracts, small business contracts, but some provisions of it, in particular Section 18. Section 18 is the section that says, in general terms, thou shalt not in trade or commerce do stuff that does or could mislead or deceive people. It's just a general catch-all, and it's almost in identical words to what used to be Section 52 of the Trade Practices Act. Those two sections themselves are the single most litigated sections, pieces of, one section in the entire history of all legislation in Australia. Because in almost every commercial deal, when there is a dispute, somebody will say, and after all of that, you are also misleading or deceptive. So we will see that come up quite a bit. International influences. This is where I give my second warning about Professor Google. One of the awesome things about Google is it helps us find stuff, particularly that law firms put out, and law firms in their marketing materials in particular can be really, really good at explaining general concepts in consumer-ready language so that we can understand them. And I will not pretend that it won't help you understand the number of these concepts, not just in this subject, but in other subjects, absolutely. One of the great things about thinking about the US in particular is the language they use is really, really similar, if not identical, to the language we use. Even some of the cases that they talk about will be very similar because they too have some history with the UK courts, particularly the really, really old stuff. But it's really easy to go down parallel lines, particularly with the US, but to a certain extent with the UK as well. You can use really, really similar language, but then mean different things in the different places. The US has a contract code in most states. Its system is more closely aligned with a civil law system in relation to contracts than a common law system. It is a different system for what we use here. And I have turned it in. I will know so easily when you have extracted stuff from US websites in particular. Having said all of that, the rules are coming together more and more because the world is getting smaller and smaller, and international trade requires consistency of understanding because contracts at their hearts are about allocating risk between parties. I feel like I have spoken about all of those things very quickly. I think it is worth remembering that we will be spending a lot of time in the UK. A lot of the cases are quite old and are largely UK cases, but not all. And we do have some Australian distinctiveness, particularly as we get into the middle of the course, when we talk about things like privity. The UK has almost abolished the idea of privity in comparison to what has happened here. So there is a certain distinctiveness also in relation to intention. The UK in some ways is much further, more old-fashioned about their thinking about intention than perhaps we are. It is worth thinking that, and it's interesting because a lot of our cases sort of go up until the early 70s. As I said, I think it's a UK case from 1977, and it's pretty much since appeals to the Privy Council were abolished in 78, and since about 96, pretty much the UK decisions have not been considered as having precedential value. So, but we're spending a lot of time in the UK nonetheless. I'm going to skip through. Oh yeah, no, I'm not. I'm going to throw them here. We've talked about these over and over again. You are going to be dreaming them. You are going to be able to deal with each of these things over and over again, and you are not only going to be able to write them out, but for each of these elements you are going to be able to identify which cases support these ideas. So I think of this, so actually I'll just throw this through really quickly. It's worth understanding that out of the 12 weeks that we are together, we're going to spend the first 7 weeks just on these elements. Some people will feel like we go a bit fast towards the end because we go quite slow, as you can tell already, at the beginning because we're building our foundations. I would love to say we'll only talk about offer and acceptance in the first couple of weeks. That is not in fact the case because clearly I've already been talking to you about what an offer is, and you see that an offer needs to be pregnant with intention, with certainty. So we will need to necessarily sort of keep going backwards and forwards, which is why we get a lot faster as we move on. So by the time we get to week 7 and we get to certainty, we're only going to spend half of that week on that, and we will continue on to look at these vitiating factors where basically, they're coming out in the wrong order. We'll spend the second half of week 7 looking at capacity, and then in week 8 we'll look at both formalities and privity. So by vitiating factors, so I'm talking about formation factors first. What do you need to create a contract? And then vitiating factors are what other things can happen that impact the enforceability of that contract. Because we've already defined that a contract is an agreement comprising the elements that we have talked about, which can be enforced in a court. So vitiating factors don't remove the ability for there to be an agreement. So you can still have an agreement, it's just the extent to which it can be enforced. There are vitiating factors that go to that. And then in weeks 9 to 11, we are going to start understanding what the terms of contracts are. And then we've got a whole week for revision. So that's the plan before you have an exam. So I want to talk, I've started to do that already, this idea between, or the difference between a valid contract and an invalid contract. That's invalid, not invalid. An invalid contract. So a contract can be valid but still unenforceable, or we could have no contract from the very beginning. And ultimately the difference, the reason that's important, goes to what the consequences will be for the parties. So whether or not you need to take everybody back to the position they would have been in if there was no contract at all, or whether or not they've just been doing stuff for luck. So from an invalid contract point of view, we just have no agreement. So there is nothing to enforce because there is nothing there. The term we use is void ab initio. I'm not a big fan of Latin. I have this theory that the only time lawyers really use Latin is when the concept is so clear in plain English that people wouldn't want to pay them for advice. My favourite Latin expression is re ipsa loquitur. It means the words speak for themselves. If they spoke for themselves, why don't you say so? Like, why don't you just use them instead of Latin? There are a small number of times when you need to use the technical terms. And particularly corresponding with other lawyers, or when you are forming something that you will need to put before a judge, you will need to use the technical terms, and they often incorporate Latin. But again, hiding behind the Latin does not make you look smart. Finding a way to make sure that a person who hasn't had the benefit of being able to look up what the Latin term means, understands what it is really important. So void ab initio means from the very beginning, right from the very beginning, so there is nothing to enforce. As opposed to an unenforceable contract or agreement itself could be valid, but one or more of the parties, not necessarily all of them, can't enforce it because of some vitiating factor. So capacity is probably the best example of that. It's really easy to think that contract was with a 14-year-old drunk kid. Clearly they did not have capacity, therefore no contract. Actually, if you have a contract, you might not be able to enforce it against the 14-year-old drunk kid because they don't have capacity, but they can enforce it against you. Because there is a contract that can be enforced and you have capacity. So I'm assuming you all have capacity. The circumstances will be different for different parties. I think the example I just gave helps with that. So it's an important distinction. What was my activity here? Sorry, let me... Yeah. Now, I'm sorry, I'm going to skip this one again while we get out of things. Sorry, I'm just both cognizant of the time, which I didn't set my timer this time. And then I'll open with another quiz when we get into the next bit. a lot of the time that you're going to spend in a contract class will be around classifying things. Trying to work out, sorry, all about me. All about me. No, it's not going to do it. Sorry, it's not that I really need it to be about me, but I'm just thinking you probably don't want to be on a film, that's all. I could be wrong. So we spend a lot of time classifying. So just think about the reading that you've done for today. You're thinking about things like, we're going to talk about the difference between a bilateral and a unilateral contract. That is just a form of contrasting or classifying different arrangements to understand how they work. You are going to be looking at whether or not a contract is enforceable or unenforceable, whether it's executed or executory. So we use a lot of classification techniques not to show off, so that we understand better what the issues might be. So I want to walk you through some of that. So really starting off at the very beginning, one of the most important things is the difference between a simple contract and a formal contract. Anybody want to hazard a guess as to what that difference might be? What do we need to have a formal contract? Signed deed is definitely a formal contract, but any kind of writing, some kind of formality that tries to encapsulate everything into one arrangement. A deed is a particularly special kind of instrument, and a deed is a creature of equity. So right at the very beginning, when we were talking about classifying a contract, one of the things we picked up was you needed to have multiple parties. Interestingly, if you use a deed, you can actually make a promise that will be enforceable against you without having a second party, for example. Similarly, you don't need consideration if you have a deed. So it's at that level of formality, which goes to, and we'll talk about a little bit more when we talk about consideration, but it seems to be, as I understand it, that the reason for having consideration is partly to demonstrate that the parties intended for there to be an exchange of some sort. But by having this deed, it's so formal that nobody could not think that it was going to be an enforceable arrangement. Deeds used to have to be put together on vellum, but no deer need to die anymore for the creation of a deed. You can just say they're a deed and execute them as such. Classifying by reference to who has ongoing obligations, unilateral or bilateral. I'm going to skip that because I've got a few slides that deal with that when we get into the next topic. And we've already talked about the difference in effect. So void having no effect, voidable being where one or more parties has the option to basically go back to the very beginning, or just unenforceable. We'll look at each of these in count. And also status. So executed, executory. Anybody want to hazard a guess at what the difference is between those terms? Yeah, Michael. So one has been completed. So which one has been completed? Executed. So the reason I always like to point that one out is often we also use the word executed to mean signed. Has he executed the deed? Has he signed the deed? But executed in the terms of a contract means everybody's obligations have been fulfilled. It's done. So buying a cup of coffee, basically whichever happens second, the handing over of the cash or the handing over of the cup of coffee, at that point the contract is executed. Executory, on the other hand, is at the point in time that we are talking about, one or more parties still has an obligation that they're yet to fulfill. All right, that's all I wanted to talk about on our first topic. Questions, concerns, frustrations, compliments. Everybody says see, and now we're going to get into like some actual content in a second. Michael, you've got something. I'm going to talk about unilateral and bilateral in the next section. We'll spend a bit of time there. So can I come back to it then? I've forgotten already your name. I didn't ask it. Hi, Joey. Don't be sorry about your name. It's a lovely name. Yeah. It will be. The reading list. I have purposefully not put the first 2 chapters of the casebook, and it's good. You can get a chocolate if you remember to send me a note about that particular thing, because I do need to fix that in the course guide. The reason that I do that is I actually think that the first 2 chapters of that textbook they're just turgid and horrible to read, and it's really boring. And actually this is a really interesting subject, but asking you, and that literally, those slides, that's all I'm going to talk about, the stuff that is in those first chapters. So I have gone for semester after semester after semester with all these people, because you're all so anxious and eager and you want to do that, and then you read this drivel, which is horrible. I keep forgetting I'm being recorded, and then you look at it and think, we hardly spoke about it in class, I'm never doing the reading in advance again. And I wouldn't blame you, quite frankly. So I think there is value in going back and having a look at that stuff probably at the end. Like when we get to week 12 and you are starting to think about, maybe plan for what kind of things you might want to do some critical analysis about, it would be useful to inform yourself about some of those different theories about why we have contract. Maybe pick one that you like, that you can argue in favour of if you have the need to do that. But I don't think anything beyond what we're talking about there. So it shouldn't be in the course guide to read it. I think the stuff that I've got in the course guide is well and truly enough to get you to where I think you need to be here at this time. But it's, the only week that I know for sure most people are going to do the reading is the first week. So I just didn't want to spoil it. That is literally an insight into my planning. There was somebody over here that... Yeah, sorry, what's your name? Sarah. So Sarah said, or asked me whether I had actually said, is it true that contracts can't be enforced against a minor, but the minor might be able to enforce the contract? The short answer to that is yes. The long answer is a little bit more complicated. That's why we're going to spend half a week on it. Depends on what kind of contract it is, what the circumstances of the minor are, a range of different things. But yes, the important point to take away from that is if there is a vitiating factor and a contract is voidable, it may be that it is voidable by one party but also enforceable by that party against the other. The circumstances for the parties might be different. But that's something to look forward to, isn't it? I probably don't give that spoiler usually so early. Okay,